What is the test for trademark infringement? Well, broadly speaking, under the Trademarks Act, there are three key grounds for trademark infringement. The first is the easy one to spot. That occurs when a third party uses an identical mark in relation to identical goods or services. Let's take Briffa as an example, which you won't be surprised to hear is a registered trademark. If another law firm used this mark in relation to intellectual property services and they use Briffa as an identical mark, it would be a clear case of trademark infringement. The second case of trademark infringement is far more common but slightly harder to establish. That occurs when someone uses an identical or a similar trademark in relation to identical or similar goods and services, and there exists a likelihood of confusion. Sticking with our Briffa example, this might occur when a law firm offering conveyancing services trades in relation to Broffa rather than Briffa. Here we would say the marks are similar, Briffa, Broffa, and the services are similar, legal services broadly, conveyancing versus intellectual property, such that there's a likelihood of confusion on the part of our likely customers. You can imagine that this test gets a bit more complicated and there are more granular elements to be looked at. For example, you can compare the marks on a visual, oral and conceptual basis. You can compare the goods and services by looking at the kind, nature, intended purpose of the goods and services and which customers they serve. You can also think about things like the earlier distinctiveness of the mark and how much attention the likely consumer is likely to be paying. The depth of this test is often overlooked, but in simple terms, let's take a trademark that's incredibly well known, Coca-Cola. Let's imagine that someone else applied to register that trademark in relation to services unconnected with Coca-Cola, let's say a hotel. In those circumstances, Coca-Cola could rely on the reputation of their trademark. They could claim that consumers would book a room in that hotel purely on the repute of that trademark. They could even claim, if the hotel proves to be bad, that they've damaged the reputation of the trademark by offering those services. This is the unfair advantage element of the test,